Welcome to this lecture on directors' duties. In this session, we will examine the legal obligations the directors owe to their companies under both common law and statute, primarily as codified in sections 171 to 177 of the Companies Act 2006. These duties lie at the heart of corporate governance and help ensure that directors act responsibly, honestly, and in the best interest of the company as a whole. So let's dive straight in. Who really runs a company? Well, we know that although shareholders are the owners of a company, the power to manage the company is vested in the board of directors. And remember, we're talking about the big public companies now, not smaller companies where the directors and the shareholders tend to be the same people. So focusing on the bigger companies, the company's constitution delegates managerial authority to the board as a collective body, not to individual shareholders or individual directors acting alone. Shareholders, therefore, have no right to interfere in board decisions unless the law or the constitution of the company expressly allows it. Directors remain accountable to the members, particularly through the annual general meeting, where they have to report on the company's performance and governance. Please do go back to the video that I've made on company management to look at the role of directors and the board in a little bit more detail. Focusing on directors' duties. Let's go on. Remember that directors are usually appointed by the existing directors or by an ordinary resolution of the company's members or shareholders. This means just an ordinary vote of more than 50% in favor. In public companies, each director must be voted on individually at the annual general meeting in accordance with Section 160 of the Companies Act. Service contracts of directors must not exceed 2 years unless shareholders approve a longer period by ordinary resolution. These rules reflect a balance between board autonomy and shareholder oversight. Remember, the shareholders are the owners of the company, whereas the directors are the managers. Broadly speaking, directors' duties can be categorized into conflict of interest duties and management duties. But remember that these duties are owed to the company and to no other person, not to the shareholders, not to the creditors, not to the employees, to the company. So keep that in mind as we go along. So once again, to repeat, the duties of the directors are owed to the company itself and not to individual shareholders or third parties. Directors' duties arise from three main sources: the common law, of course, equity, as well as statute. At common law, duties included the obligation to act in good faith, to avoid conflicts of interests, and exercise care, skill, and diligence. The Companies Act 2006 has now codified these obligations into 7 key statutory duties, and together they create a framework for ethical and effective corporate management, as you'll see. Before we look at the codification of the 7 key directors' duties in the Companies Act, let's briefly pause at the common law duties of care, skill, and diligence. In the 1925 case regarding equitable fire insurance, a company lost more than £1 million. Now that was a fabulous sum in the 1920s, and the loss was due mainly to the chairman committing fraud. The company then got into difficulties, and the liquidator then sought to make the company's directors liable for the losses on the grounds of negligence. However, the action failed because of a provision in the articles which exempted the directors from liability apart from losses caused by their own willful neglect or default. Thus, subjective-only duties of care and skill were legally recognized in the common law. In particular, the court typified this as comprising 3 rules. First, the director is expected to portray the skill reasonably expected from persons of his knowledge and experience. Second, the director's duties are of an intermittent nature. And third, if the director delegates any duty, he would be justified to trust those duties would be performed honestly. Please excuse the language referring just to he. Of course, nowadays, we also include women, but those cases still referred to the director as he. Now make a little mental note of this case, equitable fire insurance, because we'll get back to it later on in this lecture. The Companies Act has now codified the common law and the equitable obligations of directors into 7 key statutory duties. Together, they create a framework for ethical and effective corporate governance and corporate management. So once again, Section 170 reaffirms that the director's duties are owed to the company. And from Section 171 onwards, we've got the director's duties. Firstly, to act within their powers, to promote the success of the company, to exercise independent judgment, to exercise reasonable skill, care, and diligence, to avoid a conflict of interest, and finally, not to accept benefits from third parties. Also, the directors have to declare any interest that they may personally have in any transactions or arrangements concerning the company. Let's go through them one by one. The first, Section 171, the duty to act within powers. Under Section 171, directors have to act in accordance with the company's constitution and to use their powers only for the purposes for which those powers were granted. Go back to the separate video that I've made on the company's constitution and pay particular attention to the objects clause of a company, which entails that if a company has a narrow object, any actions outside of that object would be ultra vires or outside of the powers of the director. And this reinforces that the company's directors have to act according to the powers that they have. Now, the courts have developed an objective test to determine whether a power has been exercised properly by a director, and this was illustrated in the case of Extra-Sure Travel Insurance and Scattergood. Now, in this case, in order to test whether or not the director acted within their power, the court has to firstly identify what the power is, secondly, decide what the proper purpose is of exercising these powers, thirdly, to decide the substantial purpose for which the power was, as a matter of fact, exercised. So the second step was to look at what was the purpose, and the third step is to test whether or not the director actually, as a matter of fact, exercised the power for that purpose, and fourthly, to decide whether or not that purpose was proper. Examples of powers that are given to directors would be the power to issue shares, to transfer shares, or to refer or to refuse to register a transfer of shares, circulating information to shareholders, powers to borrow money on behalf of the company, to give securities, in other words, guarantees and so on for these borrowings, to call general meetings, and to make calls on partly paid shares. So in other words, shares that haven't been paid fully, to ask that they be paid fully. I just want to quote from Jonathan Crowe, who was a QC at that time, 2003. In this case, he said, "The law relating to proper purpose is clear. It is unnecessary for the claimant to prove that a director was dishonest or that he knew he was pursuing a collateral purpose. In that sense, the test is an objective one. It was suggested by the parties that the court must apply a 3-part test, but it may be more convenient to add a 4th stage." So those are the 4 steps that I've outlined here. Getting back to the quote, he further said, "The court must," I'll repeat, "identify the power whose exercising is in question, identify the proper purpose for which that power was delegated to the directors, identify the substantial purpose for which that power was in fact exercised, and decide whether that purpose was proper." End quote. So in essence, the director has to identify the specific power being exercised and ensure that its main purpose is legitimate and aligned with the company's interest. Next, we see how the Act codified the equitable duties of good faith, or the fiduciary duties owed by the director. It does this mainly by means of Section 172. Now, the common law had a long list of what they understood fiduciary duties to include, but like I said, this is mainly now contained in Section 172, which recognizes that the fundamental duty is to act bona fide In other words, in good faith in the interests of the company. So Section 172 contains that general duty to promote the success of the company. Section 172 imposes a central obligation on directors to act in a way that they honestly believe will most likely promote the success of the company for the benefit of its members as a whole. However, this is not a narrow short-term test. Directors must also consider the long-term consequences of their decisions, the interests of employees, the relationships with suppliers and customers, the environmental impact, and the company's reputation for good conduct. All of these things have to be taken into account when exercising duties for the success of the company and its members as a whole. This approach, which is known as the enlightened shareholder value principle, integrates therefore commercial success with ethical and social responsibility. The case of Hellard and others and Carvalho, the 2013 case, illustrates the importance of this duty, where the director's misuse of company funds was held to breach Section 172. Now, what Mr. Carvalho did was he made payments and bonuses to himself, his father, and he made payments from the company under his control. He also gave a huge Christmas bonus to a key employee, and there were misfeasance claims made against him. The question was whether these payments were bona fide, were they in good faith and in the best interest of the company, and it was held by the court that Mr. Carvalho was in breach of Section 172. It was a failure to promote the success of the company, and he was ordered to repay substantial amounts back to the company. Section 173 contains the duty to exercise independent judgment. Directors must exercise their own independent judgment when making decisions and must not simply follow the instructions of others. They may, however, enter into agreements or arrangements that limit their discretion if doing so genuinely benefits the company. And this was illustrated in the case of Fulham Football Club. In this case, the Court of Appeal held that an agreement to support a planning application did not breach this duty because it was made in good faith and for the company's benefit. The guiding question, therefore, in determining whether this duty is adhered to is whether the decision as a whole serves the company's best interests. Now, going on to Section 174, do you remember the case I asked you to make a mental note of earlier? The common law, as we've already discussed it in the case of Equitable Fire Insurance Company, this was the case where the company lost more than £1 million in the 1920s. And here, the court held that the standard is subjective only, duties of care and skill. So this older case regarding City Equitable Fire Insurance Company reflected a more lenient approach, particularly for non-executive directors, and it's still applicable to non-executive directors. So we only really judge them against themselves, a subjective standard. However, modern expectations are higher. Executive directors are expected to be more involved and attentive, and this reflects the professional standards of corporate management today. So this duty therefore combines both subjective and objective elements. Directors must exercise the care, skill, and diligence that would be expected from a reasonably diligent person in their position, taking into account, and this is the subjective part, their own knowledge and experience. Section 175 contains the duty to avoid a conflict of interest. Directors must avoid situations where their personal interests could conflict with those of the company. This includes taking up business opportunities that properly belong to the company or using company information for their personal gain. This rule is strict, and it applies even if the company itself could not have pursued the opportunity. Cases such as Regal Hastings and Cook versus Deeks demonstrate that directors must not profit from their position without full disclosure and authorization from the company. Let's quickly look at these cases. In Regal Hastings, a new company was formed to buy 2 new cinemas, and however, the company could only afford a certain number of shares. So the directors and the company solicitor took 500 shares each. The House of Lords held that the directors were accountable to the company for their profit that they made out of this. since they had obtained it from an opportunity which came to them as directors, and it was immaterial that the company had lost nothing since it had been unable to make the investment itself. The directors might have retained their profit if the company had agreed by resolution passed in a general meeting that they should do so, but they didn't. In Cook versus Deeks, the directors of a company negotiated a series of contracts for the company, and when the negotiations were complete, they took the last of the series of the contracts in their own names. It was held by the court that because the directors were acting for the company at the time of the negotiations, the benefit of the contract belonged to the company. The directors could therefore not take the benefit of those contracts for themselves. However, do remember that it is possible to obtain the company's permission even at a later stage, which is what ratification means. Agreement after the fact. Next, Section 176, the duty not to accept benefits from third parties. Section 176 prohibits directors from accepting benefits from third parties that arise by reason of their position, where such benefits could compromise their independence or create an appearance of impropriety. In short, this boils down to bribes. For example, cases of bribes or secret commissions. How does it differ then from Section 175? Well, unlike Section 175, this duty applies even when the company could not have received the benefit. Take note that this section does not contain a provision for authorization by the Board of Directors. So in Section 175, the directors' benefits could have been pursued legitimately by the company itself, whereas in Section 176, the benefits that the company itself could not have requested or accepted were accepted by the directors. So once again, we're talking about bribes, impropriety. The emphasis here is on maintaining integrity and public confidence in corporate governance by directors. Section 177, the duty to declare any interest in proposed transactions. This entails that directors must declare to the board any personal interest, whether direct or indirect, in a proposed transaction or an arrangement with the company. Failure to disclose such interests may constitute a criminal offence under Section 183 of the Act. So transparency is essential. The declaration allows the board to make informed decisions and helps preserve trust within the company's governance structure. What are the consequences of breach of any of these directors' duties? When a director breaches any of them, several consequences may follow. Under the Insolvency Act 1986, directors can be held personally liable for wrongful or fraudulent trading and may be required to compensate the company for losses. The Company Directors Disqualification Act 1986 also empowers courts to disqualify directors for up to 15 years if their conduct makes them unfit to manage a company. A disqualified person who continues to act as a director commits a criminal offence and may be held personally liable for the company's debts. So some pretty serious potential consequences. Are these prohibitions against directors absolute? Well, we've already seen that directors could, for example, make a profit in their personal capacity, provided that they get the company's permission. So no, not all breaches automatically result in punishment. Certain actions can be ratified by the company's members. Section 239 of the Companies Act specifically provides that this could be done, ratification could be given, provided that the conduct that is ratified is not illegal or fraudulent. And it's always a company's choice to prosecute a matter or not. However, serious misconduct, such as theft, fraud, or bribery, cannot be condoned. Penalties may include fines, imprisonment, or civil remedies such as restitution and damages. Ultimately, these rules reinforce accountability and the principle that directors must always act with integrity, diligence, and loyalty towards the company. So remember, there are criminal penalties as well as common law remedies, civil law remedies, which include damages, restitution. In conclusion, the duties imposed on directors represent a carefully balanced framework, and it's designed to protect companies, shareholders, and the public. These duties require directors to combine good faith with professional competence and independence with accountability. In a separate lecture, separate video, we will examine the enforcement of these duties and what steps shareholders can take to hold directors to account, including a very powerful tool called the unfair prejudice petition and derivative actions. Thank you for watching and see you in the next one.